Good afternoon, everyone. It's Chris Barnett. I am a NARC board member checking in from the great state of Michigan. And I also serve here as a township supervisor as my full-time gig. Many of you hopefully know what townships are, but we are like a city or a village, but in Michigan and in the Midwest, we have townships. So glad to be here with you today. Fellow NARC members, we are joined by a very special guest. And I'm really excited about this subject today that we're going to be covering. So here at NARC, it's been important and a priority of the administration and as well as the board to try to bring timely and topical webinars to our members. And this one is certainly a big one. And many of you have probably been following what's gone on in the last 6 months. At the Supreme Court level, and that's our topic today. So we are joined, as I mentioned, by a very special guest. Lisa Soronen is the executive director of the State and Local Legal Center, and in her role, Lisa files amicus briefs to the United States Supreme Court on behalf of the members of the Big Seven. What is the Big Seven, you ask? Some of you probably know, but if you don't, it's the National Governors Association, the National Conference of State Legislatures, the Council of State Governments, the National League of Cities, the United States Conference of Mayors, the National Association of Counties, and the International City and County Management Association. That's a mouthful, but she does that in cases affecting state and local government. So she is our dear friend, and she's fighting for us. So prior to joining SLLC, Lisa worked for the National School Boards Association, the Wisconsin Association of School Boards, and clerked for the Wisconsin Court of Appeals. She earned her JD at the University of Wisconsin Law School, and more importantly, she's a graduate of the great Central Michigan University located right here in Michigan. Anyway, I am going to be quiet, but I just wanted to give you a couple things here before I actually officially turn it over to Lisa. We want your comments, we want your questions, we want your feedback, and the best way to do that is to add it into the chat function of the webinar. I'm sure many of you are pros at this, as this has been our life for the last 8 or 9 months. So if you have questions or comments or things you'd like us to cover during this webinar, please add those in the chat function, and we will do our best to get those questions to Lisa and or NARC staff to get answers for you all. With no further ado, it's my pleasure to turn it over to Lisa. Thank you, Lisa, for joining us. We're grateful for your time.
Thank you so much for that introduction. I wish you guys could see me smiling. So there is a lot to talk about it when it comes to the Supreme Court and local government specifically, and in the last couple of months, even more specifically. So this is what I'm going to talk about today. I'm going to talk about the Chief Justice's sharp turn left last term. I'm going to talk about some interesting cases from last term, and I'm going to talk about the death of Justice Ginsburg, court reform, Justice Barrett, and some interesting cases from this term. Obviously, I won't be able to cover all the things that are interesting and relevant to you in your capacity as local government officials, but I tried to pick the topics that NARC focuses on specifically, like environmental issues, public safety issues. The court doesn't deal a lot with transportation, but you guys have never held that against me. So let's start looking back at last term for a moment. So all eyes were on none other than the Chief Justice. And the reason was because the court had just a bevy of controversial blockbuster cases that it was deciding last term. So if you look at the topics on the screen, normally it would take the court about 10 years to hear all these topics, and they were hearing them in 1 year. So it was really kind of an incredible term. But even more incredible than the topics was last term, for the first time in 50 years, we were supposed to have a real conservative Supreme Court majority of 5 justices. So basically, since about 1970, we've had a conservative Supreme Court with one squishy justice. That's a justice who is conservative, but not reliably so. So for the most famous one is, of course, Justice O'Connor, and the one we've had most recently is Justice Kennedy, and that was for about the last 12 years. So Justice Kennedy was replaced by Justice Kavanaugh, who his last term was only his first term. And I should say that court's terms sort of start and end October 1st to about June 30th usually. So There is a caveat, though. There's 2 stars on the screen next to Chief Justice Roberts. Some people wondered how reliable the Chief Justice would actually be as time went on. So it's important to know this about the Supreme Court's docket. Most of the cases on the court's docket are not decided on ideological grounds. And most of them are also not decided 5-4. In fact, about 50% of the court's docket is unanimous. 20% of the cases are 5-4, and only about half to maybe a quarter of those are controversial. But if you look at the court's term for the last 9 years, that's the time that I've had this job. If you look at all the big controversial cases, I can only think of 2 cases where that weren't 5-4. So in the big controversial cases, most of which don't directly impact local governments a ton, the ideological split on the court really does make a difference. So what happened last term was that the Chief Justice joined the liberal justices in a bunch of rulings, one involving abortion, one involving DACA, and one involving Title VII, sexual orientation and gender identity. So you might ask if his turn left has been overstated. I think the absolute truth to that is yes, and I think that I'm a big part of the problem. My friend Adam Liptek at the New York Times said that really if you look at Roberts' record last term, what he did was he steered the Supreme Court down the middle, doling out victories to the right and the left. The problem is that when he voted with the right, that didn't get a lot of attention in the media because that's what people basically expect him to do. So all this hoopla is generated when he votes with the left, even though at least half the time he's voting with the right. So the transgender gay rights case is basically, the holding in the case is that under a federal employment statute called Title VII, that protects people on the basis of race, gender, religion, etc., that gender identity and sexual orientation are now covered as well. Out of all the Chief Justice's liberal votes, this one surprised me the most because the Chief Justice didn't join his more liberal colleagues in the same-sex marriage case of about 4 or 5 years ago. The difference between this case and that case, other than one involved marriage, is that this involves an employment statute, not a constitutional ruling. So the Chief Justice knows that Congress can, change a statute anytime that it wants. The other thing is that Justice Kennedy was the champion of gay rights in the Supreme Court, and I think it would look odd if, as soon as he left, suddenly the court moved in another direction on gay rights, and I think the Chief Justice was sensitive to this. So most people speculate that the reason why the Chief joined the liberals in a couple of cases is that he doesn't want the court to look political. Because there's 5 justices currently on the court who were appointed by conservative presidents. If they all vote together, the court just looks like a political institution. People push back though and say, well, doesn't it make the court look political if a justice votes different than his politics to sort of not look political? And I see the point to that. Other people have also speculated that the Chief wanted to sort of reduce focus on the Supreme Court in the election, and that's why he joined the left as well. That might have worked had Justice Ginsburg not died. For those of you who remember Roberts' confirmation hearings, he said rather famously, my plan is to call balls and strikes, and he's been noted as a jurist who likes narrow rulings and moving the court slowly. If you look at this term in total, that's what you see out of a lot of the decisions. Even the liberal decisions would only move the court slowly and slightly. So here's the deal. If the Chief Justice's goals are what we think they were, they unequivocally and absolutely paid off. So look at this Gallup poll data. Can you imagine Congress having a 58% approval rating? This is right before Justice Ginsburg died. Can you even imagine a president right now having 58% approval rating? And look at the number for Democrats. 56% of Democrats polled were happy with the Supreme Court. Now, it's important to keep in mind the Democrats would have lower expectations for the Supreme Court because they know it's conservative. But getting 56% of Democrats to approve is just no joke. It's actually pretty darn impressive. So I'm now going to talk about a couple cases of interest decided last term. I'm not going to focus on a lot of the blockbuster cases because they're not the bread and butter work that you do as a NARC member. So I'm going to focus on an environmental case that's a little bit tricky to understand. I've probably explained this case 20 times, and I still don't feel like I necessarily explain it all that well. But it's a Clean Water Act case. And the holding of it is when there's a functional equivalent of a direct discharge from a point source to a navigable water, an appropriate permit is required under the Clean Water Act. So this case was widely reported as a loss for local government. It's, I think, basically a loss, but it's a little bit more complicated than that. But I wrote the decision and it was 6-3 with the conservatives joining some of the liberals, or Kavanaugh and Roberts specifically. So basically what the Clean Water Act does is it prohibits the addition of a pollutant from a point source to navigable waters without this particular federal permit. The facts of this case make the case a lot more understandable. The County of Maui operated a bunch of wastewater treatment plants, and what they would do is they would inject treated wastewater into wells. So treated wastewater is considered to be polluted or have a pollutant in it, and a well is a point source. Then the water would transfer from the well through groundwater to the ocean, which is a navigable water. So everyone agrees, if the water would have gone directly from the well to the ocean, this federal permit would be required. But because it went through groundwater, there was a question about whether or not this is covered under the Clean Water Act and a permit is required. Well, you might just say, well, why wouldn't a local government just get a permit? I mean, you know, keep it simple. The reality is getting the permit can be expensive and in some instances not necessarily even possible. So Maui argued that basically if the point source is the means of delivering the pollutant, like if the pollutant directly goes from the point source to navigable waters, then, you know, a federal permit should be required. Hawaii Wildlife said, no, if it's fairly traceable that the pollutant got from a point source to navigable waters in a fairly traceable manner, a permit is required. And here it was fairly traceable. I mean, everyone agreed that the polluted water went through the groundwater and went to the ocean. So ultimately the court held that a permit is required when a discharge is the functional equivalent of a direct discharge from a point source to navigable waters. So a functional equivalent. The court said, you know, we can't rely on fairly traceable because water on a bird's wings to the ocean is fairly traceable, but you wouldn't require a bird to get a federal permit. The court also said, you can't just say, you know, if it has to be a direct connection between a point source and navigable waters, there has to be some daylight between that and, you know, and what people would do in real life, which is they would just cut off a point source, you know, a foot from navigable waters and say, look, there's no direct discharge. So what is this functional equivalent of a direct discharge? Well, in true Justice Breyer fashion, the court came up with a 7-factor test, but said that time and distance are the most important. So the reason why this case is considered a loss is the court could have simply said a federal permit isn't required in this case. And by coming with a 7-factor test, it means litigation is sort of inevitable as this case goes forward, or as this issue goes forward, rather. So I always wonder about talking about Reed versus Town of Gilbert to an audience that is mostly non-lawyer, because it's kind of a technical case. But I've been at this job for 9 years, and in my opinion, the very worst decision out of the Supreme Court in 9 years for local governments was Reed versus Town of Gilbert. The court held in this case that strict scrutiny, which is also called fatal scrutiny, applies to content-based restrictions on speech. So just trust me when I say this, governments historically have made content-based restrictions on speech all the time. And what the Supreme Court basically said is almost any content-based restriction on speech is unconstitutional. So this case came up in a sign code. And just to give you an idea of the implications of this case, here is a list of all kinds of laws that have been struck down as unconstitutional because of Reed. I mean, think about a harassment statute. That's saying you can't engage in speech on a certain topic. I mean, you can see how an ordinance like that might get struck down. So my organization, the State and Local Legal Center, is on a mission to get Reed overturned. And if it sounds crazy to you, it somewhat is. The Reed decision was 9-0, and it's only 5 years old. So why would the Supreme Court be inclined to change it? Well, 3 justices concurred in Reed and expressed skepticism about how far the opinion went. So last term, the court accepted a case, is the first case like interpreting the Reed decision. And it was a federal debt collection statute, so it doesn't impact local governments at all. So this SLLC filed an amicus brief asking the court to basically overturn Reed versus Town of Gilbert. And Justice Kavanaugh accused Justice Breyer, joined by Justices Ginsburg and Justice Kagan, of basically trying to do this. Now, I will remind you, you cannot overturn Supreme Court precedent in a dissent. And Justice Breyer, Ginsburg, and Kagan were in the dissent. But it was pretty funny that, the justices were saying, hey, you're like trying to overturn precedent. So Justice Sotomayor would not have applied strict scrutiny. She wrote a separate opinion, which is basically the same thing as saying she'd probably be inclined to overturn Reed. And here's the kicker. Justice Gorsuch wrote a separate opinion. He applied strict scrutiny, but he didn't cite to Reed, which made people think there might be 5 votes on the court to overturn Reed. But of course, Justice Ginsburg died. We don't know a ton about Justice Barrett's views on Reed, but we'll find out about those shortly. So the next thing I'm going to talk about in terms of last term is this. The biggest thing by far that the Supreme Court did for local governments last term, other than, the sexual orientation, Title VII, gender identity, Title VII ruling, is the court did not take a series of cases asking the court to modify or overturn qualified immunity. So if we were in person, I'd ask you to raise your hands and ask you how many of you heard of qualified immunity before George Floyd died. And I'm guessing most of you have heard it now. So basically, this is what qualified immunity is. My husband, who's a non-lawyer, is always asking me to remind him what it is. So there's a federal statute. It's called USC Section 1983. And it says that state and local government officials can be liable for money damages if they violate the Constitution. Qualified immunity is a defense to this Section 1983. It's a defense to constitutional violations. So local government officials and employees can get qualified immunity if the law they violated wasn't clearly established. So basically, everyone gets qualified immunity except the plainly incompetent and those who knowingly violate the law. So qualified immunity is very favorable to local governments, and it's, even though the individuals are technically personally liable, it's the local governments who pay the money damages. Qualified immunity is very controversial because it's essentially a one-time free pass that allows you to violate someone's constitutional rights and have no consequences when, and the when is extremely important, the law isn't clearly established. And the policy reasons that support qualified immunity is that, why should someone be morally, financially, and legally responsible for something when it wasn't clear that it violated the Constitution? So I always try to remind my audiences when I talk that it's important to realize that the police officers that killed and watched George Floyd being killed would not have received qualified immunity. It is clearly established that a police officer cannot put his foot on the neck of someone who is lying on the ground and not fighting. And it's also clearly established that police officers cannot sit around and watch a colleague, kill another person for no reason. So qualified immunity came up a lot in the George Floyd debate. It's still coming up. But like I said, it would not have applied in that case. So for years and years and years, the Supreme Court has taken a lot of cases sort of defining qualified immunity. But what's been different, or what was different than last year, is a bunch of people asked the Supreme Court to modify or overrule the doctrine, not to just correct the lower courts who might have applied the doctrine wrong, but to rewrite the doctrine or even get rid of it. These cases piled up, and ultimately the Supreme Court decided not to hear them. Supreme Court always gets to decide. It takes 4 justices to grant a petition. They can decide what they want to hear or what they don't want to hear. 10,000 petitions are filed a year before the Supreme Court. Almost all of them are denied. So you might wonder, why is this such a big deal? Well, there's been a war on qualified immunity, and justices have criticized it. Lower courts have criticized it. A think tank called Cato is filing briefs all over the country criticizing it. And there's this non-ideological group that filed an amicus brief asking the court to overturn qualified immunity. There's advocacy groups on the right and on the left. So we don't know why the Supreme Court decided not to get involved in these cases. There's basically two going theories. The first theory is that the liberals on the court might want to do something about qualified immunity, but they probably don't have enough support from conservatives, so why even go there? The second theory is that the justices knew that Justice Ginsburg was going to die and they'd have a new colleague, and they didn't want to put so much pressure on the new colleague as to have to decide whether to get rid of this extremely important legal doctrine to local governments. So I also think it's important to highlight that this does not mean that qualified immunity is safe. Colorado has gotten rid of qualified immunity for local police officers, interestingly not for state police officers, because it's the state legislature who is acting. There's a proposal in Congress to get rid of qualified immunity for police officers. So, you know, your legislative sessions are going to start in January if they don't go around year round. And believe you me, in many of your states, you're going to have proposals to get rid of qualified immunity. I think a lot of people misunderstand it. It's a complicated doctrine. I've actually put a document together that gives all the sort of policy reasons for defending qualified immunity. If any of you are interested, you can email me and I'd be happy to send a copy of it to you. So now I'm going to talk about the death of Justice Ginsburg and what it means for a variety of different stakeholders. And I'm going to conclude by talking about the very controversial topic of why she might have died on the bench rather than have left earlier. So if you haven't seen either of these movies, I highly recommend them. There's a Hollywood movie on Justice Ginsburg's life and a documentary. I'm not sure that before I did this presentation, or I'm sorry, before I saw those movies, that I knew that she had argued personally 6 gender discrimination cases before the court. She's definitely most famous for her dissents. Most Americans can't name a Supreme Court justice, and if they could name one before, it would have been Justice Ginsburg. So it's kind of amazing that a Supreme Court justice got the status of cultural icon. There's nothing inevitable about that. So for local governments, she was on the court for decades. Bill Clinton appointed her. And all justices are a mixed bag for local governments. There's no justice, no matter what their ideology, that cares deeply about local governments and always votes in their favor. I think something that was overlooked about Justice Ginsburg, though, that was really important about her was that in the kind of mine run, regular local government, not that controversial cases, she was as much a pragmatist as she was a liberal. And that really made some difference in her jurisprudence. I'm just going to tell you one brief story. So South Dakota versus Wayfair, some of you may remember this decision. It was from a couple of years ago. The Supreme Court held 5-4 that states could require out-of-state retailers to collect sales tax. And to come to that conclusion, the court had to overturn precedent, okay? So this decision was either the last or the second to last decision that Justice Kennedy participated in and wrote in. So all the justices knew that he was leaving the bench. And so, like I told you, the vote in the case was 5-4. It was the conservatives plus Justice Ginsburg. So this is the word on the street. Like, no one knows this to be a fact. It's just speculation that the liberal justices weren't willing to vote with South Dakota in this case because they didn't want to vote to overturn precedent, knowing that Justice Kennedy was leaving the bench. They were worried about Roe versus Wade. But Justice Ginsburg, the story goes, or the thinking goes, was kind of like, this has nothing to do with Roe versus Wade. This is just like common sense. Like, why shouldn't Amazon be required to collect sales and use tax? So, like I said, that's kind of a non-ideological case, not a liberal or conservative case necessarily. And I think Justice Ginsburg's real pragmatism shined through, which is really important to local governments. So when you look at the impact of her death on the court more generally, again, my friend Adam Liptak at the New York Times said, she will move the court slightly but firmly to the right, making compromise less likely. So you might ask, well, why only slightly? Well, Chief Justice Roberts is pretty conservative. And now the deal is this. We are going to have a 6-3 court. We are not going to have a 5-4 court in conservative cases most of the time. The justice at the center will be Justice Kavanaugh. Neither he nor Justice Gorsuch have done a lot of swinging so far. In fact, Justice Gorsuch, of the two of them, joined the liberals, in that Title VII sexual orientation, gender identity case. Justice Kavanaugh, though, has not joined the liberals yet in any controversial cases, but he will, and that's going to happen this term. So this is my, there are definitely some liberals in the audience. There's some conservatives as well. And I think, there are liberals out there who are feeling a little bit downtrodden and concerned about the court. And I actually think there is a little hope for you worried liberals. And this is what it is. And I haven't read anyone else who said this, but I'm sure I'm not the only person thinking it. Roberts, Gorsuch, Kavanaugh, and Barrett will never be liberals. Never, ever, ever, ever. But if the chief wants to go liberal, he only needs to peg off one of them, right? He doesn't need all of them in any given case. And there's only, typically 2 or 3 big cases a year. If he's able to peel off one of them once a year, the court may have more liberal rulings in the future than we think. That's already happened in one case. It's going to happen in another case with Justice Kavanaugh. And, all these people, you have to remember, they're human beings. They're not just ideologues. And they all have their idiosyncrasies. And so I don't think that, that liberals have to be as worried as they are. So a rather controversial topic among liberals as well, that people were only sort of willing to talk about a little bit after Justice Ginsburg died was, why did she stay? She was 87 or 88 years old. She had cancer 4 times, and she could have left during the Obama years. So my husband is a consultant, and he sees my presentations, and he says, they have so many words, no one wants to listen to all this. So this is my picture. It's just kind of funny. So this is an Onion article, and the subject of the Onion article is that President Obama tried to convince Justice Ginsburg to die when he was in office. And he had suggested, so the Onion says, that she died by throwing herself to a pack of wolves. Of course, I'm being facetious, but it just makes a larger point of, she stayed on the court for a really long time. So there's basically 3 theories. The first one is that she thought Hillary Clinton would win 4 years ago. That's what everyone thought, basically, except Michael Moore. She's an absolute workaholic. And if you watch the movies, you'll learn that about her. But the third theory is kind of the most interesting one. So if the Chief Justice is in the majority, he gets to decide who writes the opinion. And that could be a really powerful thing. And Reed versus Town of Gilbert is a perfect example of why. I can guarantee you any other justice who would have written that majority opinion would not have written as broadly as Justice Thomas. So if the Chief Justice, whoever he or she might be, isn't in the majority, it's the justice with the most seniority who gets to decide who writes. So there's an abortion decision from a couple of years ago. The Chief wasn't in the majority, but Justice Kennedy was. And he assigned the opinion to Justice Breyer. If you read that opinion, it's called Whole Woman's Health. Justice Ginsburg wrote in an opinion at the end, a concurring opinion that was about 3 paragraphs long. Basically, all she said was, I agree with Justice Breyer. Why would you write an opinion like that? You write an opinion like that if you're mad that you didn't get to write the majority opinion. My point is, once Justice Kennedy was out of the way, Justice Ginsburg occupied a position of a fair amount of authority. The justices are mostly equals of 9, but not entirely, and the writing power sort of illustrates this. So the death of Justice Ginsburg has super significant implications for the Chief Justice. He can no longer sort of save the institution by joining the liberals anymore because there'll be another conservative vote. There'll be 5 solid conservative votes to sort of ignore him. He can no longer signal to his colleagues, look, I'm not ready to go there. I'm not interested in voting in that way. Or he can signal, but his conservative colleagues won't care because they don't need his vote. But this is the biggest thing that he cares the most about. The Chief Justice is a conservative. I do believe that. But he deeply wants to control the pace at which his conservative colleagues move to the right. And he wants that pace to be slow. He has and will lose control over the pace already. So people have asked me, is it likely that he'll dissent for institutional reasons? The short answer, I think, is generally no. And this is the reason why. No one remembers their dissents. They don't have any real impact. And the other thing is what I just said. By staying in the majority, he gets to control who writes the decision, and he gets to control then sort of the breadth of opinions. But there's a big but here. those of you who followed the news carefully over Thanksgiving saw the story about the court getting involved in this case out of New York. The New York governor had said if you're a church and you're in a yellow or a red zone, you can only have 10 or 25 people at church. The Supreme Court in a 5-4 decision struck that down. All the conservatives on one side, the Chief Justice with the liberals on the other side. The Chief Justice reasoning, unless you read the articles pretty closely, you might not have gotten to this, was that no current church was currently in the yellow or the orange zone. Or red zone or whatever it was, they were in a different zone, so they could all operate at 50%. They were all happy with operating at 50%. So there's kind of like no reason for the court to get involved in the case. That's what the Chief Justice said. The other liberals said, well, I shouldn't say other liberals, the liberals said, look, movie theaters are closed entirely. Churches can have 25 people. They should be happy with that. Anyway, what's interesting about that case is that there's a lot of interesting things about it, like the chief dissents. Amy, we know how Justice Barrett voted in this case. Typically, the court won't issue opinions in cases, and this was an emergency motion case, which is kind of a technicality, but it's odd that Justice Barrett's views would be made known on an issue so quickly. The court doesn't do a lot of emergency motions, and it's interesting that we come up in the context of religion because, Justice Barrett was a controversial choice because of her strongly held religious beliefs. So I personally think that the hardest choice the Chief Justice would ever have had to make, as sort of the center of the court, he never had to make. And that's because the issue just didn't come up. The Chief Justice dislikes race-based decision-making. He dislikes affirmative action. He thinks that the best way to stop discriminating on the basis of race is to not look at race. And Justice Kennedy held those views as well. But at the end, the very twilight of Justice Kennedy's career, he voted in favor of an affirmative action plan. In the time between Justice Kennedy leaving and Justice Ginsburg dying, the court did not hear a case where race-based decision-making was front and center. Just didn't hear a case. So Justice Roberts didn't have to sort of make that ultimate choice, like, can I vote in favor of an affirmative action plan for sort of, saving the court as an institution sort of reasons, or will I stick with my colorblind theory of race jurisprudence. I also think it's an interesting question to wonder if a 6-3 conservative court is what the Chief Justice wants. I think it's the same as asking, is he more of a conservative or more of an institutionalist? We don't know. But I also think it's interesting to think about this. So 4 years ago, 4 years and 2 months ago, I was giving presentations talking about the Hillary court. That was going to be a 7-2 court with the Chief Justice in the minority. Is he happier now than that outcome? I think it's impossible to say. So until October of this term, I never talked about court reform. People would ask me questions about it in presentations, but I never did a presentation on it. And there were 2 reasons why I didn't talk about it. 1, I didn't think it was likely. 2, I didn't think it was mainstream. I still don't think it's likely, but I do think it's mainstream. The reason why it's not likely is this. For Congress to do something in the court reform space, they basically need 60 votes or to get rid of the filibuster. Let's say there are 50 Democrats ultimately after this Georgia thing works itself out. That's not enough. So even if all the Democrats said, yeah, let's do court reform, there'd have to be 60 votes or the filibuster would have to go. But I think the Democrats sort of have to talk about this topic, if nothing other than the sake of pride. I also think it's important to always remember this about the Supreme Court. No matter how you view the ideology of the justices, there's always a generation gap. And by that, I mean that, I think Clarence Thomas was appointed around 40, but Justice Barrett is closer to 50. I heard someone once say, you don't want a justice on the Supreme Court who hasn't had a midlife crisis. So invariably, the people that get on the Supreme Court, whether they're liberal or conservative, are always like a little bit behind the times. I mean, that's just kind of how it is. And this kind of came up in an interesting way in Justice Barrett's confirmation hearing. She used the term sexual preference instead of sexual orientation. I went to a very liberal law school. I live in a very liberal city. I have not heard the term sexual preference probably in 2 decades. But she apologized, for using the term. But I say it just to illustrate that, like, there's always kind of a frustrating gap with the court, and it's hard to figure out how to close it. So some people have wondered, is court reform a solution in search of a problem? Like, why do we have to change the makeup of the court? Why are we even talking about it? Well, the reason why we're talking about it is that what happens is that justices basically leave the court when they retire, which can be 30, 40 years into the job, or when they die, which can also be 30 or 40 years into the job. And so the appointments are made sort of randomly. And my friend Paul Clement, who was a Solicitor General of the United States, said, you know, back in the day when the Constitution was formed, this system made a lot of sense. The Supreme Court was not intended to have a large role in our society. It was supposed to have a very limited role, in fact. And at the time of the Constitution, the court had no judicial review, meaning it had no ability to declare a statute unconstitutional. But more to the point, like I'm reading this book called Nixon Land, and oh my gosh, the LBJ Congress, they're passing laws right and left. You know, in the last 4 years, I can think of one really significant piece of legislation, which is, of course, tax reform, and then another one, some criminal justice reform that was pretty minor. That's not the Congress that our founders intended. So what's happened is that the Supreme Court has taken on an elevated role, as have administrative agencies, because Congress is not as active as it could be. So if you're really interested in this topic, there's a great website that offers basically a summary of 9 different reforms. The most common reform is adding seats. This is called court packing. It's popular because it can be just done by a statutory change. But I personally am not a big fan of this because I think it would just lead to tit for tat. So eventually we have 100 people on the Supreme Court because the Republicans don't like it one time, the Democrats don't like it another time. It just doesn't make a lot of sense to me. The reform I do like that I think makes a lot of sense is the 18 and out. This is the idea that the justices would serve for 18 years and then they would have to leave. May most likely go back down to the lower courts. Kind of a demotion, but I think they could handle it. So what I like about this is that every other year, there would be a Supreme Court vacancy. The problem with this is it might require a constitutional amendment because the Constitution says that justices and judges serve on good behavior, not on good behavior in 18 years. And remember, it's the Supreme Court that would decide whether this could be done by statute or by constitutional amendment. So President-elect Biden has tried to be as vague as possible about this, kind of keeping his options open. He's talked about a bipartisan study commission. I don't think that's necessary. I think that, you know, everyone kind of knows what the main proposals are. He's also said he would not want to get rid of life tenure. So the last 2 things I'm going to do in this presentation is I'm going to take a closer look at Justice Barrett and her impact on local governments and her impact more generally. And then I'm going to look at some cases from this term of interest to you as local government officials and NARC members specifically. So what's interesting about her personally and professionally is she's not an Ivy League East Coaster who worked for the federal government. There are a couple of justices on the court that meet all 3 of that criteria. Every justice on the court except her meets 1 of those criteria. She clerked for Justice Scalia, and she doesn't have a long appellate record, unlike Kavanaugh and Gorsuch. She is a textualist and an originalist and a social conservative. And I think just kind of a conservative in general. I'm going to talk briefly about what's likely going to happen in 3 kind of big topic areas. The ACA, guns, and abortion. Abortion, I'm just going to talk about it for a second because it's not really a local government issue, but I think it's an issue that just you as an American are probably interested about. This is what I would say, and this is really important for a non-legal audience to understand because lawyers already know this, but I agree with people that say that Roe versus Wade has never been more vulnerable, but I also think it's important to remember this. The Supreme Court never, ever, ever has to decide the question of overturning Roe versus Wade. That's always the Supreme Court's choice. Now, 4 justices can call the question if a case comes up. But the point is, like, there's no automatic way that Roe versus Wade gets overturned. And I should also say, too, I'm focusing on these 3 topics because these came up a lot in Justice Barrett's confirmation hearings, and they're the topics where the Chief Justice has held back, either is voted with the liberals or hasn't been aggressively conservative. So the ACA case, again, like, this doesn't necessarily affect you that much in your capacity as a local government official, but this is just such an important piece of our culture. It's hard to ignore it in a Supreme Court presentation. So as you all probably remember, the Supreme Court held in 2012 that the individual mandate that requires you to pay money if you don't get health insurance was constitutional as a tax. Okay, so Congress gets rid of that dollar amount and says, now your shared responsibility payment is zero. You don't have to pay any money if you don't buy health insurance. So how can there be a tax, right, if you don't have to pay any money? So everyone kind of agreed that this case would come down to what's called severability. That's the idea of, can the rest of the ACA stand even though the individual mandate is unconstitutional? The law strongly favors severability. The law basically says we try to keep statutes. If part of them are unconstitutional, we just get rid of the bad part and we keep the rest. So what happened last term, and most people don't know this, is that in two separate opinions, Roberts and Kavanaugh wrote basically these love letters to severability, talking about how much they love severability, how important that they thought it was. So what happened in oral argument was the Roberts and Kavanaugh basically both said, this law is clearly severable. I mean, we can clearly keep parts of it. And in oral argument, justices ask questions, they don't make statements. So for Kavanaugh and Roberts to just make the statement, look, we think this law is severable, it's pretty strong, you know? So you might wonder, like, why was Chuck Schumer like crying on TV about Amy Coney Barrett and the fate of the ACA? It's because, you know, you got to follow the Supreme Court really closely to know all the individual moves that the justices are making. So guns, public safety is a big interest of NARC members. A lot of local governments regulate guns and have rules that limit them in some way. In the last 10 years, the Supreme Court has refused to review over 150 gun cases. And all the Supreme Court has said is that individuals have a right to a gun inside their home for lawful purposes. The court has never said that we had any individual rights to a gun inside our home for lawful purposes. So in June, the court had 10 gun petitions, 10 opportunities to take a gun case. They did not take any of the cases. They denied cert in all of them. And people were absolutely shocked. So the theory was, Roberts said, don't go there. And he said, don't go there to his conservative colleagues, either because he didn't want to tackle the issue now or because he might not be willing to vote with them. I think ultimately Roberts will join the conservatives on the gun issue, but he might just not have been ready to go there. So here's somewhere where Justice Barrett, when she was Judge Barrett, had done some actual decision making. So in the Cantor versus Barr case, white collar criminal could not have a gun because he was a felon. He said, look, I'm just like Martha Stewart. Like, I'm not dangerous. I should be able to have a gun. Majority of the Seventh Circuit said, no gun for you. But Justice Barrett, then Judge Barrett, said, yes, you should be able to have a gun because the founders would have wanted you to have had one. So by looking at what the intent of the founders, that usually leads to more conservative results rather than balancing like the interests of individuals and the government, which is what most courts do. So I am still sad that this wasn't my idea, but it wasn't. My friend, Stephen Vladeck at the University of Texas, said that gun cases will be like a candy to the Supreme Court. So here's the interesting thing. I just found out that the Third Circuit decided a case identical to Cantor versus Barr, where it was another white-collar criminal who was a felon who wanted to have a gun. And interestingly, two judges said, nope, you can't have a gun. And a third judge dissented, citing to Justice, then Judge Barrett, saying you should have a gun, or you should be able to have a gun. All this to say, the Supreme Court will issue a ruling on guns, probably sooner rather than later. And I do like to remind the audience, it is interesting that there is more consensus on guns in this country than probably most people realize. 60% of Americans actually want gun laws to be tougher. Here's the problem. The agreement where people have like, there should be background checks at guns, private gun sales. If you have a mental illness, you shouldn't have a gun. Those are not likely the issues that are going to go to the Supreme Court anytime soon. I found this remarkable too. 44% of people know someone who's been shot. I actually know 2 people, myself personally. So, you know, NARC focuses a bunch on environmental issues. So I'm going to end by talking a little bit about Justice Barrett's views on that topic. The truth is they're basically unknown. but her views really actually probably don't matter all that much, and this is why. So most environmental regulation on the federal level, it has involved agency action. Most agency cases are heard by the DC Circuit. Justice Kavanaugh sat on the DC Circuit for 10 years. We know a ton about what he thinks about environmental regulation and federal regulation in general. And the short answer, he's not a big fan of it. So his views are actually more important than Justice Barrett's. But I thought it was interesting at the confirmation hearing when she was asked whether she thought climate change was happening, that she wouldn't answer the question and said that that was a political question. I really didn't think I really don't think that's a mainstream political question. I don't think most people in the mainstream think it's controversial whether or not climate change is happening. What is political is what should be done about it. So anyway, that's just kind of an interesting side note on that. So Justice Barrett was only on the Seventh Circuit for 3 years. Most of the cases that she decided on topics of interest to local government that repeatedly go to the Supreme Court were just kind of involving applying settled precedent. She wasn't being asked to make any new law because that's not really what lower court judges do. So she had very few rulings in free speech and qualified immunity and takings. The rulings that she did have, I found to be very reasonable, very middle of the road, very not out there. So I think as, she's perceived as being very conservative, but that's going to have more of an impact in the big cases. It has less of an impact in the smaller cases that local governments often deal with, just because those cases aren't decided so much on ideological lines. So I'm going to finish up my presentation, and remember, if you have questions, to put them in the chat, by talking about some cases of interest to local governments. The truth is, there is just a bevy of interesting cases that I could talk about. I'm not even going to scratch the surface on talking about all the interesting cases for local government. And this is the reason why. The court had a bunch of local government cases last term that they moved over because they didn't have time to hear them because of the pandemic to this term. And last term, the court just had a lot of blockbusters. So this term, they've taken a lot more bread and butter, kind of regular local government cases. Cedar Point Nursery versus Hassid. This is all I have to say about this case. If you think Reed versus Town of Gilbert was bad, this case could be so much worse. And there's a lot of reason to be worried about this case because it's a takings case. And the Supreme Court is very primed to rule against local governments in a takings case. Conservatives feel very strong about land use and private property rights. The question in this case is a temporary easement a taking? So here's a brief overview on takings law. So the Fifth Amendment allows governments to take property, but the government has to offer just compensation. There are 3 categories of takings. One category is called the per se taking. And for there to be a per se taking, the Supreme Court has said there has to be a permanent physical invasion. Now, the facts of this case is really kind of crazy. So California has state law, I think, adopted in the 60s or the 70s that said that if you're an agricultural employer, unions could come and organize on your property 3 months out of the year, 3 hours a day. And this law might seem kind of crazy to you, but you have to consider the fact that still in this country, agricultural workers often live on site, so they don't go home to a place outside of their employer. So the agricultural growers said, this is crazy. You're taking our property. You unions are coming on 3 months out of the year, three hours a day. That's got to be a taking. When the Ninth Circuit said, no taking here because there's no permanence. It's only 3 months out of the year. It's only 3 hours. A dissenting judge said, no, property owners should be able to exclude people. So think about this from a local government perspective. Think about all the times local governments temporarily go on private property to do police work, do health inspections, do code enforcement. Local governments are going on private property all the time for short periods of time. Historically, courts have not looked at these cases as takings under the Fifth Amendment. But if the court considers there to be a taking in this case, that could change. I think there's an easy way out of this case for the Supreme Court. I think what the court should say is that the easement basically here was permanent. I mean, if you're really going to be on someone's property 3 hours a day, 3 months out of the year, aren't you kind of permanently there? But we'll see what the court decides to do. BP versus Mayor and City and County of Baltimore. I am not a less is more kind of person. I am a more is more kind of person. But this case, I'm going to tell you less about it rather than more, because it's absolutely overwhelming and confusing for me to explain and for anyone to understand. In fact, I tried to explain this case today and it was a total disaster, but I can explain it in very general terms very, very easily. A bunch of cities and states have sued big oil over climate change. They are required to bring state law claims. The Supreme Court has said no federal claims are even possible. They have brought these claims in state court. Why? Because they think that state judges understand state law better, and because I think they think that state law judges might be more sympathetic to climate change cases. Unsurprisingly, the oil companies want these cases to be heard in federal court. This case has to do with how easy it will be for local governments and states to keep these cases in state court. So these cases don't decide the ultimate question of whether or not these climate change cases are possible, whether they can be brought, what the damages are, and they don't even definitively define whether or not they can be heard in state or federal court. But the decision is will decide how easy it is for these local governments to keep these cases in state court, which is where they want them. So I think this is the last case I'm gonna talk, or I guess it's the second to last. Oh my, got a little bit ahead of myself. Got two more cases I'm gonna talk about today. One of them is a pretty significant public safety case, maybe one of the most significant I've seen in a long time. The issue is whether or not the Fourth Amendment caretaking exception to the warrant requirement extends to the home. So this is one of those Section 1983 money damages claims where the officers were accused of violating someone's constitutional rights and were going to have to pay money damages. So basically what happened, it was husband gets angry, takes out a gun and throws it on the table and says to his wife, "Why don't you just shoot me?" She gets scared and she leaves for the night. She tries to call her husband the next morning, he doesn't answer. So she asks the police to go over to his house. So she and the police officers go over to his house. These officers determined that he should have a psychiatric evaluation. He says they told him that they wouldn't take his guns if he would agree to go to a psychiatric evaluation. So he went to psychiatric evaluation. What do you think they did? They took his guns. He said, "Wait a minute, you seized me by forcing me to go to a psychiatric evaluation, and you took my guns and you didn't have a warrant. That violates the Fourth Amendment and you should give me money damages." The First Circuit, in an opinion where Justice Cedar was sitting on the court, said, no warrant is required because the police officers were acting here in their community caretaking function. They were there to check you out and to see if you were okay. But interestingly, the Supreme Court has never extended the community caretaking function beyond a car. The court said in 1973, okay, if your car's on the side of the road and we think there's a gun in it, we should probably get the gun out because someone might break into your car and steal it. So we're not going to get a warrant. We're just going to take the gun out just to kind of like help take care of you and take care of your property. Never been extended outside of the home. But if you think about this, this would happen all the time. Police all the time help people. And in the process of helping people, find an opportunity to do a search or a seizure. It would be great if they didn't have to get a warrant, because if they don't, then they can't be sued for money damages if they fail to get the warrant. The First Circuit basically said we want to extend this community caretaking function to the home, just because this is so much of the work that police want to do. I think there's a tension in this case between police officers doing legitimate caretaking and sort of cops gone wild. I mean, what you don't want is police officers pretending to be caretaking but really trying to just do warrantless searches. And so I think we're going to ask the court to sort of draw the line that, a police officer would have to be engaging in legitimate caretaking functions. So I'm just going to finish with this one last case, because it illustrates a dilemma that local governments have right now and that they're going to have going forward. This is part of kind of a cultural war issue, and the local governments are caught in the middle, and this case is a perfect illustration of this. So as you all know, the First Amendment of to the United States Constitution talks about religious rights. I mean, we've had them since the beginning of history. Our country was founded on religious freedom. That is just a fact. But the court has also recognized gay rights, and specifically the right to marry as a gay person and as a constitutional right. So what happens when those rights get in tension or are at tension? The reality is that oftentimes local governments are caught in the middle. So what happened in this case, this is Fulton versus City of Philadelphia, is that Catholic Social Services work with the City of Philadelphia to place foster kids. Catholic Social Services would not work with gay couples, but the city had a non-discrimination ordinance. And the city basically said to Philadelphia, you have to follow our non-discrimination ordinance and you have to work with gay couples. The Second Circuit or the Third Circuit agreed and said that Catholic Social Services had to work with gay couples. So at the oral argument in this case, the liberals basically said, we don't see what the big deal is here. Why don't the Catholic Social Services just say, like, hey, we don't endorse same-sex marriage, but this couple otherwise qualifies or doesn't qualify to be a foster parent, like, so they can make their views known. What's the discrimination against them? The conservative justices said, look, foster parents can work with all kinds of agencies. They don't have to work with Catholic Social Services. So gay foster parents can just go somewhere else. In fact, no gay couple has ever tried to work with Catholic Social Services. I think the Catholic Social Services is going to win, but my point is this. This is going to be a narrow case. There are going to be many, many cases on this intersection of gay rights and religious freedoms. It's just not going away, and local governments are going to continue to be stuck in the middle of it. Okay, so that is all I have for you guys. I have finished 3 minutes early, so not too early. I can look in the chat box. When I talked to the major metro NARC people last week, I mean, there's just tons of questions. So I do encourage you, if you have a question, to go ahead and ask me.
I have you. Good. Hi, Lisa. It's Chris. My webcam seems to not be working, so good news for all of you. You don't have to look at me. But first of all, thank you. Wow. I took lots of notes. The good news for all of you that are watching this is that this has been recorded and we're going to make the presentation available. You should get a link emailed to you if you register for this webinar, as well as we'll be posting it to our website. So tons of great information. If you haven't seen Lisa before, it's even better in real life in person, back in the old days when we used to be able to meet in person. So thank you, Lisa. I do have a few questions that came in. Again, this is Chris Barnett. I'm one of the NARC board members. And I'll just read these to you, Lisa, and if you could answer these, it would be appreciated. And then before I read the first question, I just let all the members that are online know that if you have a question, please submit it now. If we can't, oh, there I am. If we can't get to it with Lisa, we will try to get the answer for you after. And then the other thing I would share is that if you have any ideas for other webinars you'd like to see us bring to you, as I mentioned at the front end, it's important to the administration of NARC and the board that we're staying in front of our members with important information and topics during the pandemic and even beyond. So you can put that in the chat function as well. But here's your first question, Lisa. Do you think the court will move to more federalism so that liberal states can be liberal and conservative states can be conservative instead of a one-size-fits-all format that we have now? Would this be a solution to avoid more conflict and to allow the court to back away from big political issues? Your thoughts?
That is a fantastic question. I commend whoever thought about asking that question. So I do a presentation every year for Georgetown, and it's a federalism class, and I talk about the Supreme Court and federalism. And so one of the things I ask my student audience is, can you be a liberal and a federalist? And and the smart students say, yeah, you can. And the instance in which you can is when you don't like what the federal government is doing and you like what states and local governments are doing. So, but to answer your question more directly, it's hard to say like what direction exactly the Supreme Court will go in. But I will say this, that as a practical matter, all the justices kind of use federalism and arguments about federalism as a tool to kind of get the outcomes they want. So, liberal justices tend to embrace federalism when it's state and local invention that they like. And the theory is that conservatives care more about federalism and support it more. I don't actually think that the data actually bears that out. I think what it bears out is more that justices are inclined to don themselves in the federalism mantle, just like other mantles, when it gets them the outcome they want. So the short answer is, I don't know if the court would do that, but it certainly is one solution to sort of, reducing some of the tension and the controversy. It's a great question.
And an even better answer, as we've come to expect from you, Lisa. No pressure. Here's another good one. Can you share what you've seen with the Supreme Court weighing in on elections-related disputes? Do you expect any more surprise cases before the inauguration?
So absolutely and unequivocally, this is one of my favorite topics to talk on. I mean, to be honest with you, I've pulled it out of my presentations because it's now kind of more the past, but I gave tons and tons of presentations on the subject. So this is sort of what happened. This is the lay of the land. Tons of judges basically made changes to state law due to COVID. And those changes, in theory, affected the impact or affected the outcome of the election. They might not have affected the ultimate outcome, but they did affect how many votes were counted in particular states. Probably the best example is a number of states through judges extended how long ballots could be received beyond the statutory deadline because of COVID and because of problems with the mail system. So the court heard, oh man, 7, 8, 9, 10 of these cases. And it took a long time to figure out where the justices were ultimately coming down. All this has happened before Justice Barrett got on the bench. And basically, Justice Roberts was controlling the outcome of the cases, and eventually his views became known. So this is the line that he drew. He basically said, if a federal judge changed a state statute, I don't want any part of that. That federal judge is going to get struck down. But if a state judge interpreting state law decides to modify a statute, I'm fine with that. And how this played out was in Wisconsin and in Pennsylvania. In Pennsylvania, it was a state court based on state law, extended the ballot receiving deadline. Chief Justice Roberts said, green light, no problem, Pennsylvania. In Wisconsin, it was a federal judge not applying state law that said, I'm gonna extend the COVID or the deadline to receive ballots. And what people pointed out was the brilliance of the Chief Justice was that, he was really kind of walking a federalist line saying, I'm going to allow some of this to go forward, but it's going to be the state courts interpreting state law. We're a federal court. We should stay out of state election decisions. Brilliant. Told a really great line. I personally, I think the election's over. I don't think the Supreme Court is going to get any more involved in any of these cases. I think it's done. But the justices have surprised me before. Another fantastic question. I'm thinking maybe it's a New York Times piece. Whoever asked the question, if you're more interested in this, email me, because there is a great article that just sort of describes how Roberts just came up with this theory, he applied it, and he stuck with it, and that's what ruled the day.
Very good, very insightful. This is more of a comment, and I think everyone that's been with us for the last hour would agree. Lisa is amazing, such a great speaker for non-lawyers and non-DC folks, which, by the way, is probably most of us. And I would agree. I was almost thinking I wish my daughters could hear all this insight. How hard is it to get excited about an hour-long presentation on the Supreme Court? But man, Lisa, you do a great job. We're really grateful for you and your support and commitment to NARC. It looks like all the questions. There was a couple more comments in there. We'll leave those, but we will be sending this webinar out. As mentioned, it's been recorded and we'll be posting it to our website and also sending it to those that registered. There were a couple people that looked like they might have had some audio issues, but it was clear here, so I'm sure the recording will be clear, so we can make sure everyone gets the information. And then again, if you didn't comment today or have questions, if you want to send those to NARC staff, we can try to get those answered. Or if you have ideas for other future webinar topics that would be helpful or important to you in your region, let us know and we'll try to accommodate that, because that's really important to to NARC staff and NARC's board. So with that, Lisa, is there anything else you want to, any closing thoughts before we wrap this up?
No, just thank you guys so much. It was a pleasure to do the presentation.
I thought for sure you were going to talk about how fond you are of Michigan. It's your favorite state of the union, but I'll let that slide. Thanks again, Lisa, and thanks to NARC staff for organizing this webinar. We will now conclude this presentation. Thank you. Have a great afternoon, everyone.